Welcome to my video guys. Today we'll be discussing one of the key topics of law of torts, which is vicarious liability. Vicarious liability means liability of one person for the act done by another person. Here, even if a person hasn't committed a wrong, he'll still be held liable for other person's act. However, vicarious liability will only arise when there is a specific relationship between two persons and the wrongful act committed by one of them is in connection with their relationship. Having a specific relationship is a necessity and it could be of any of the three types. Firstly, the principal for the tort of his agent. Here, the relationship exists between the principal and the agent. Secondly, the partner of each other's trust. Here, the relationship exists between two or more persons. And lastly, a master-servant relationship. So, a principal for the tort of his agent means where an agent commits tort while performing his duty assigned by the principal, and during that period of time he commits a tort, then the principal will be liable as well as there will be joint liability of both towards the plaintiff. This relationship is determined by one of the most crucial legal maxims, which is qui fecit per alium fecit per se. This means that an act of an agent is the act of a principal. Here, when an agent performs a wrongful act in the ordinary course of his duties, then the principal is held liable and plaintiff can sue either the agent or the principal or both. The case which perfectly determined this relationship is Trilok Singh versus Kailash Bharti. The facts of this case is that Trilok Singh was outside the town and his younger brother Sukhdev Singh took Trilok's motorcycle without his permission and caused an accident because of his own negligence and rash driving. The decision given by the judge emphasized on non-liability of Trilok as it wasn't his business in which Sukhdev was engaged in. As a result, the liability of compensation to the plaintiff was on Sukhdev Singh and not on Trilok Singh. The next type of relationship is partner of each other's trust in a firm. Here, if a tort is committed by one partner in ordinary course of business, then all partners will be held liable. At this point, the guilty partners and all other partners are considered as joint tortfeasors and have a joint liability. The main case for this is Hamlin versus Houston and Company. In this case, one of the partners of a firm bribed the plaintiff's clerk to commit breach of contract. Both the partners of the firm were held liable for the act of one partner. Now we'll talk about the most important relationship under vicarious liability, which is master-servant relationship. Here, a master is liable for wrongful act of servant if the act was committed in course of employment. Of course, the servant is liable too, but firstly, we'll talk about who is a servant, who is an independent contractor, and the difference between them. A servant is a person employed by another to work under directions and control of master. On the other hand, an independent contractor is a person who undertakes work to produce a given result, but in the actual execution of the work, he is not under the order or control of the person for whom he does it and may use his own discretion. The difference between them is firstly, a servant is subject to control, on the other hand, an independent contractor is not. Secondly, servant has to do certain work in certain manner. However, an independent contractor is his own master and can work on his own discretion. The main case for independent contractor is Morgan versus Incorporated Central Council. In this case, plaintiff lawfully visited defendant's premise. There, he fell down from open lift at his premise and got injured. It was held that the job of lift was given to the independent contractor. Therefore, no liability of defendant will arise as independent contractor does not work under the master or the owner. As every rule in law has some exceptions, similarly, there are a few exceptions to this as well. In the following cases, the employer can be held liable for the act of independent contractor. First, authorities or ratifies an illegal act. If an employer ratifies or authorizes an illegal act of independent contractor, then he is held liable as he himself is a party to that act. Secondly, liability of employer for acts committed on strict liability. In this case, the Rilland versus Fletcher, plaintiff couldn't escape water and the construction of storage of water was done by the independent contractor, but still he was held liable as it comes under strict liability. Third, liability arises when the act was caused on the near highway. In this case, in the case of the Terry versus Ashton, the plaintiff was injured by the falling of lamp which was attached to the defendant's house. It was held that the defendant will be held liable as it was his duty to take care. Fourth, breach of common law. Tort results when there is a breach of master's common law duties to his servant. And last, nuisance. Wrong caused as nuisance in form of withdrawal of support from neighbor's land. Now we'll discuss upon the liability of master in case of master-servant relationship arise when the act was committed by servant and the act was committed in the course of employment. A few case laws about the master-servant relationship is Poland versus Pious and Sons. This case is solely based on the mistake of servant. Here, a boy was stealing sugar from the servant's master and the servant struck the boy, which made him lose his leg. The master was held liable for this act committed by the servant. The next case is based on lending of servant. It is Kundan Kaur versus Shankar Singh. In this case, drivers were lended to Jawahar Transport Company to transport goods. Kundan, a guy, was sitting beside the driver in the truck. Due to rash driving and negligence, Kundan was killed. The person who lent drivers were held liable because they have direct control over the drivers. The last and one of the most important cases is Cheshire versus Bailey. This case deals with the theft by servant. In this case, it was held that when a servant steals something, then the master can't be held liable for it even if the servant bailed that good to the master. So now we can see that to make the master liable, there has to be a servant who has done the act and the act has to be done in the course of employment. That is all for now. Thank you for watching my video, and if you have any doubts or queries, then feel free to comment below.